Hey, good Saturday afternoon. Carl Rominger here answering your legal questions on Weekend Appointment. 540-0580. 540-0580 is the talk line number. If you have a legal question, legal concern, call in. We'll answer it here on the air. Of course, as always, I ask you to keep names of businesses and people anonymous. You know, if it's the cable company, just call it the cable company. Of course, they're a monopoly, so I guess we know who you're talking about. If it's your neighbor, just call it your neighbor, not Mary Smith across the street with the yellow Volkswagen Bug who lives in the greenhouse. We don't want everybody and their brother to know who we're talking about because, as always, this is not a privileged conversation. If you need to talk to me about something that is privileged or sensitive and you don't want it on the radio, you go to weekendappointment.com. You can email me from there for a private consultation. You can also call my office from there to set up a real live meeting with me. So, Elmer, you're on WHP 580 with Carl Rominger. What's going on?
Yes, Carl.
Yes.
Yes, I'm a landlord, and some people tell me on your notice to pay rent or quit, can that be put into your lease agreement as to negate that?
What do you mean?
In other words, if you put it in your lease,
right,
and they sign it, that you wouldn't have to give them that 10-day notice, just take them right to court.
It is possible to do that. It is possible that the lease can allow for that. My advice is still to give the notice to quit, even if it's just a short one. I would usually put in the lease a 10-day or a 5-day.
Right.
And there's two reasons for that. Number one is I think a court could interpret, the person says, well, I didn't realize I was behind. So give them a little leeway. You don't want to be stuck with that. More importantly, then I'll tell you this. When you go to evict somebody, if they're behind on their rent, they're going to be able to pay and stay if they can pay. So giving them a notice to quit actually protects you from having to file an unnecessary district justice action because if the only issue is the rent, you can't evict them as long as they pay. So giving them a notice to quit and a demand to pay kind of remedies that problem because if they go ahead and pay you, then you'll know not to waste the money on going forward.
That's the other question. We have a person now that we have taken to court and got the notice to evict them, right?
Right.
And then they have paid us in between that. How long does that notice good for or whatever?
They can pay off up and until the time the constable actually evicts them.
Okay. In other words, it might be good once you give them that notice and take them to court, it could be 2 or 3 months later. You wouldn't have to go back to the magistrate, is what you're saying.
Right. Once you've got the order of the magistrate. Now, here's the problem with the pay and stay.
Yeah.
They're going to go ahead and let's say 3 months down the road, and they get the money off Grandma or Uncle Ted or somebody,
right,
and they hand the constable the money. Now they're back on under the lease or back to month again. Any way you want to look at it.
Right.
What you really want to do when you have a lease is make sure it has enough stuff in it that they could possibly be in violation of or find some violations of the lease. A lease violation, besides non-payment, does not allow for pay and stay. So if you want to get a deadbeat tenant out who might be able to pay and stay, you got to find a lease violation. So let me tell you, when I represent landlords, I will usually tell the tenant, hey, we'll waive a month of rent if you'll agree that you're in violation of paragraph 3 of the lease.
Yeah.
That way we get an agreement that's not pay and stay. On the other hand, if I represent the tenant and the landlord's unrepresented, I'll usually say to the landlord, listen, we'll agree that we owe you X dollars in rent, but we don't agree that we're in violation of paragraph 3 of the lease. So we'll agree the judge can enter an order saying that we owe you the rent. Most landlords don't know about the pay and stay.
Yeah. I've heard you say that before. That's why I wanted to call and ask.
Yeah.
It gets a little confusing for me.
It does. And, Elmer, what I would tell you is make sure you have a good lease. Don't go to the Office Max and buy one. Don't go to the Staples and buy one. Have somebody write a custom one for you that does what you want it to do. Right. And there are some little tricks that we can use in those that make it more powerful for the landlord later on.
Well, boy, I need the help with the conditions of the day. These tenants are beating me out of thousands of dollars.
Right. And the other thing is, and on the front end, I always counsel people 2 things. Number 1, consider credit checks on the tenants.
Right.
Number 2, if you really if you really don't have a ton of apartments, I mean, if you have 3 apartments, 4 apartments that you're renting out, it might behoove you to get a professional property manager to assist you. They usually take the first month's rent on a new tenant and then a 10% fee, which sounds like a lot, but if they're doing all the credit checks and handling the tenants on a day-to-day and getting all the repairs done, it can make a landlord's life a lot easier.
Oh, they get all the repairs done.
Yeah, yep. Well, I'll tell you what, I use a guy to manage 2 apartments, and he takes care of everything, a realtor, yeah.
But in the end, you wind up paying for all the repairs and what have you.
Oh, I have to pay for that. That's right. But I also don't. When the tenant calls and says his toilet's plugged up, he doesn't call me.
Yeah. And
I don't get up in the middle of the night and get the plumber. That's part of the fee that you pay every month.
Right.
All right, Elmer, I'm gonna let you go. I got some more callers here.
Thank you. Yes, sir. Yes,
hey,
sir.
Thank you for listening. Great having you on the phone here. Take care.
Thank you. Bye-bye.
540-0580. Carl Rominger here. I'm an attorney at law answering your legal questions. Janet, you're on WHP 580 with Carl.
Hello.
Yes.
My son works for a retail store in Lancaster, and he was called into the office where he was asked what he had shoplifted. And when he explained to them that he didn't steal anything, they continued for an hour asking him and berating him what he had stolen.
Mm-hmm.
Finally, after about an hour, he had a doctor's appointment. He said, I have to go. I have to go for my doctor's appointment. And then he left. He hadn't stolen anything. The next day he was told that they do that, kind of like a shakedown type thing. In case he would have taken something, then they would have found out that way.
Nice.
Is that legal?
Is it legal? I mean, I think the answer is yes. And here's why I say that. I mean, he's an adult, right? He's 18?
He's 19.
19. Short answer is an employer can be unreasonable. An employer can be a jerk. And so if they call you in like that, want to do that, I guess they can. I don't see what's per se illegal about it. Nobody physically restrained him. And obviously when he got up and left, they let him leave, right?
Yes.
So,
and he continues to work there. They have not fired him. They have not even cut down his hours. He continues to work.
Right. And I think that's a little unusual, though I've not heard about that. Is this a national retailer of some sort?
Yes.
Okay. He might want to, or somebody might want to anonymously go to the next level of management and find out if this is really something that's done there. That sounds a little unusual. I've never heard of that done before.
Yeah.
But, hey, I don't know. But it does sound to me like a fishing expedition, and it does sound inappropriate. If he were to quit because of that, I think he would be able to get unemployment and say, hey, my employer acted so unreasonably and treated me so poorly that I can no longer...
I don't think he wants to quit. He likes working there. It just he was taken by surprise because he had not shoplifted, and for an hour they kept him in the office questioning him, and then even going as far as to saying it may be on his personnel record, but he didn't steal anything. And
this may be a individual manager, not a national policy of some sort, and so that's why I suggest maybe there's a way to find that out without circumventing the chain of command and having them come back and get angry with him if they're in fact jerks. Because in Pennsylvania, an employer can be a jerk. I mean, that's the short answer.
Okay.
All right, Janet. Thank you.
Okay. Thank you.
540-0580, 540-0580. Carl Rominger answering your legal questions. I'll see you after the break. Hey, 540-0580, 540-0580. Call in with your legal questions. And what else I want to update you guys? I got some callers here I'm going to take in 1 second. Make sure you go to weekendappointment.com, check out what's going on. I will be attending an NRA banquet in Carlisle today at 4 o'clock. I know I talked with them today. They do have a few extra tickets, so if you're interested, go to weekendappointment.com. We've got the information to contact up there and where it's at. They do have a few extra tickets if you want to come. I don't think they have 100 extra tickets, but they do have a couple. So $40 gets you in for the banquet. Starts around 4 p.m. and goes till about 9. There's an auction, there's a dinner, there's drinks, a lot of fun stuff there, and a lot of people who like guns, which is why I like to go. Sam, you're on WHP 580 with Carl Rominger. Sam.
Hello, this is Sam.
Yeah, what's going on, Sam?
Hey, Carl. I work for a coffee company that just recently decided they were going to go from having their own people servicing their equipment to an outside company. And the outside company, what they did is through a number of service conference calls over the last year. They guaranteed everybody that they wanted everybody to work 40 hours or even more. But then whenever it really came time for us to work, I mean, the work that they're giving us is maybe only 16 to 20 hours a week. Do I have any recourse against the company other than just to file for unemployment compensation?
I think that's it.
That's it?
I think that's it, unless you can show they did it because you're one of the protected classes, either, because you're old, because you're black, because you're Muslim, one of those kinds of arguments. But the reality is, again, and that's what I was telling the other caller earlier, in Pennsylvania, employers can just kind of be jerks. They can go back on their word. They can tell you they just don't like the color of the shirt you wore today and fire you. I think your only remedy is unemployment or partial unemployment even, which is to say that they've cut my hours.
Right. And even, they even had us sign a non-compete clause, which isn't allowing us to go work for other companies that maybe do the same thing.
Well, and it's interesting. Now you're onto something interesting, because now let's go a step further. Then, if they were to try to enforce that against you, you may be able to say that you fraudulently induced me into signing this by telling me one thing and doing another. And I wouldn't have signed it if I realized that I was only able to work 12 hours a week or 15 hours a week.
Yeah, correct.
So, and what I would do, preemptively, here's the thing. If you find a new employer and you go to them, they may say, well, you have this not compete. I would hire you but for it. Some employers would say, you know what, I'll hire you, and if they do anything about it, I want you to defend it, or I'll even help you defend it. Or if the employer says, I can't hire you because of it, but if you can get out from underneath it, I will. That's when you would come see a guy like me, and we would go for what's called a declaratory judgment, where we'd ask a judge to declare it invalid on the basis of the contract itself being flawed. So we've invalidated a lot of non-competes over the years because the law doesn't favor them. Sometimes the employee hires you, and sometimes the prospective new employer hires you because they want to be able to free somebody up to work for them.
Okay. Hey, thank you very much.
All right, my friend. Thank you.
Thank you, Carl. Bye.
Reminds me when I was a kid, I worked in a pizza shop, and I'm in high school, and they say, oh, you come in after school and you can work like a couple hours, and then, only need you like a couple days a week, so you'll be able to do your homework and play your sports and everything. And like all employers, they lie. And so about 2 weeks later, I look at the schedule, and I got 47 hours for the next week, and I'm thinking, 47 hours, I've got to go to school, and how am I going to play on the tennis team in the spring? So, yeah, employers have a way of changing the landscape from what they originally say they're going to do until later. And I think sometimes that's intentional, and many times that's just a fact of business, which is, okay, he's available, and then they just keep adding hours and hours and hours, or they keep taking hours and hours away, depending on how their business cycle's going. 540-0580. Nicole, you're on WHP 580.
Hey, Carl. I've been listening to the last couple of callers, and I know that Pennsylvania employers can be jerks. But what I am is a medical professional, and I know that last year they passed a law about mandatory overtime and that they are not allowed to make you work overtime because of short staffing.
That's the Medical Professional Overtime Act or something. I'm trying to remember the exact name of it, but you're correct. It's to cut down on overtime, mandatory overtime for people in the medical profession and related fields. There's two countervailing theories on that. One is it's designed to protect medical professionals so that when the nurse comes in to give me a catheter, she hasn't been standing on her feet for 87 hours straight.
Right.
The other theory on that is, from the other side, is that's the union folks wanting to make sure that the employers have to employ more people rather than simply claim they're short-staffed, which increases the number of employed individuals.
Okay, so my what I want from you is your opinion, because you could say, okay, I go in and tell my employer, well, because we're short-staffed, you're making us work X amount of days for however many hours, and that's all because of short staffing. Would we be protected because of that law? Or you go in and say that, and then next week you're a minute late and they fire you anyways, just because you know what I mean?
Well, okay, now let's tease that out a little bit. First of all, I think it's called the Excessive Overtime and Healthcare Act or something along those lines. I'd have to actually look at the language of it to see what your remedies are and whether it has any teeth in the sense of what does the employer have to show or does the employee have to show to be protected under it or not protected under it. But like everything else in life, yeah, if you invoke that on your employer and then there's some other pretext to fire you, they might not do it today or tomorrow, particularly if they're clever so that you can't show the quid pro quo. But then they say, oh, you know what? You did what? Oh, my gosh, your break was 25 minutes. That's 5 minutes over the break allotted time. I have to write you up warning 1, and then a week later, warning 2, and a week later. So like everything else, you have to pick and choose your battles.
Right, and that's what me and some other employees have spoke about is like, do you say anything? And with this economy, it's like, you almost like grin and bear it because it's like, do you work the overtime because you have a job and be happy with that? Or do you bring it up and then, you could lose your job next week? Right,
and that's, the answer on that is, it's just kind of one of those things where you have to sort of think back and forth and say, which way do I want to go? Also,
online though, it really doesn't protect you.
Well, and that's
way,
and nothing protects you if you don't complain about it. If that makes sense. I mean, as with all the other anti-discrimination laws, employment laws out there that potentially could protect you. We've had a few other callers over the last year that have called in with similar situations where they've kind of said, my employer is having me do something I don't think is appropriate in terms of how much hours I have to work or whatever, but I don't want to lose my job. So what do I do? And, that's the problem. Now, if you could show that they retaliated it against you under the act, I don't know if it has any teeth or not. So I have to look at that. Do me a favor, post it on weekendappointment.com.
Okay.
I'll pull up the act and get the language on there for us, and we'll take a look at it, and then I'll give you an opinion.
Okay, great.
Because right now I'm stabbing in the dark, except to say that as in all matters, I've had employees come in to see me on workers' compensation type matters, but let's say they're at work and somebody hits them with a car, and it's not somebody from the employment place. And I say, well, you could put this through workers' comp. And they're like, I don't want to put it through workers' comp. I don't want my boss will get all upset if I do that. And I'm like, well, you can, and they'll pay your medical bills and they'll take care of this. And then we could still sue this guy, but you'll have everything taken care of up front. I don't want to put it through workers' comp. And there's and maybe it's justified, maybe it's not. They just assume that by making that claim, they're going to upset their employer. And since they have another way of being made whole, they'd rather wait and go that route rather than risk retribution later from the employer. Although a lot of times I don't think that's actual or it's ever a threat that's even been made. They just assume that they're going to somehow lose good graces by making such a claim.
Okay, yeah.
All right, Nicole, post that on weekendappointment.com and I'll take a look into it.
I will. Thank you, Carl.
Thank you.
Bye-bye.
I cut her off too short. Shane, my thumb probably needs to be slowed down a little bit on this button here. 540-0580, 540-0580. Dave, you're on WHP 580.
Hey, what's going on, Carl?
Not too much. What are you up to?
Did you ride your bike in today?
I could have.
Yeah, you should have. Hey, I wouldn't usually call, but this circumstances, this created the worst day of my life. What did it? 05, I've been in pain management, right, for my back, and you signed, your narcotic agreement and everything, and you agreed to, the screening of urine and stuff. So I said no problem. So last time I was in, they screened me, and I'm on 2 main pain medicines, the oxycodone and a methadone. Well, the methadone makes me a little tired, so whenever I have my son, I don't take it. You know what I mean? It just helps me. So he flagged me for it, and he says, I can't get your medication. He says, I'm going to have to put you on Suboxone. So I have no idea what Suboxone was. So he said, have you had this before? And I said, it sounds familiar, but I don't know. He says, well, did you ever put it under your tongue? And I said, no, I've never put any medication under my tongue. And he goes, oh, well, you never had it. So to make a long story short, he prescribes this to me. So I go down to the pharmacist right downstairs. And, meanwhile, I had my full daily dose, of opioids before I went in there. Mm-hmm. So I popped this thing under my tongue. Dude, 20 minutes driving home, I was seeing pink elephants and helicopters flying everywhere. And then my heart started racing, so trying to think where to go, because I could barely drive. It was like muscles started locking up and things. So I made it down to my family's position, down in New Cumberland, ended up getting an ambulance ride over to Holy Spirit. And then they said it was because, with this Suboxone, I guess that's supposed to after you're done for 24 hours of opioids, then you can take it. But since I had my full-blown thing, it just put my brain into a whirlwill. And it just, I couldn't believe he did it. And then, he even screwed up on the bottle with, the dosing. Not that I took more than one, but
right.
Is there any recourse that I have of that? I mean, as far as...
Well, the short answer is, I mean, if in fact you're prescribed a drug that you shouldn't be taking and it harms you in some way, it's a medical malpractice claim.
In other words, he gave it to me, prescribed it to me, but didn't tell me how to take it.
Right.
So,
and
since I had the full blown, I had my pain medicine in me, I went right downstairs and put it in my mouth when he should have told me to wait 24 hours.
Right, and that's potentially malpractice. Now, here's the next question: is what was the harm? And the short answer is you did have a very bad experience. Potentially bad things could have happened. Could have had a car accident. You could have.
I got an ambulance. I mean, I had taken ambulance and everything. And the thing was, I had even called back right when I first started feeling the symptoms because I knew it was something I never felt before. And I called the nurse, and she says, "Oh, Dave, just drive home." And I told her, I said, "I can't make it."
Let me tell you, here's your problem. In Pennsylvania, in order to assert a medical malpractice claim, you're going to have to file a claim with the court. In order to do that, you're going to have to hire an expert to tell you that you have merit. And for the amount of money that you would pay an expert doctor, a couple $1,000s to look over everything and give you an opinion and write it down and say you have a claim, that will exceed the cost or the likely recovery of your claim for such a short period of time, even the ambulance bill. So
the thing that was stupid was even after all this happened, of course they wouldn't take me back unless. So I had to go. He said, "Well, anyway, I'll take you back." I had to go to a psychiatrist for 2 hours. I had to go to some opioid therapist thing. And they said they both gave me the okay. And basically, they said it was an honest mistake. I don't know why he was playing such hardball with you, because I was taking like close to 50 pills a day, 30 milligram oxycodone, and then I went to nothing, and then I took that stupid Suboxone. So
you might want to talk to somebody about taking that many of those things. All right, I got to let you go because I had to go into my half-hour break here.
It was 16 a day. I'm sorry, not 50. I'd be dead.
All right.
All right, later.
540-0580, 540-0580. We'll see you after the break. I was just flipping through RJ's issue of Cosmo here. Always good reading. 540-0580, 540-0580. George, you're on WHP 580 with attorney Carl Rominger.
Hello?
Hi, George.
Yes, sir. I was working at a nonprofit organization last year, and I was terminated and tried to get unemployment, and unemployment commission granted me unemployment, but I didn't get it because it was a nonprofit organization. Is there any recourse I have with the company?
They terminated you exactly for what reason?
They said non-performance of duties or whatever.
The answer is your only recourse, again, unless you can show it's because you're a member of a protected class and that's the reason they did it, is to file for unemployment compensation in Pennsylvania. Mm-hmm. And under the unemployment law, it's their duty if they terminate you to show it was done for willful misconduct. Mm-hmm. So next question is whether or not your non-performance was willful misconduct or not. And that's a question for the court.
I tried to take it to the Human Race Commission. They told me the same thing you just told me.
Yeah, and so you're very limited here in Pennsylvania. But again, it has to be that willful misconduct. So the answer is if you didn't show up for work 10 days in a row with no call, no show, that sounds like willful misconduct. On the other hand, if you just were, they gave you tasks to do that you just weren't capable of performing or just had a hard time completing, or more importantly, maybe they were just unrealistic, like they said, call these 1,000 people between now and 2 p.m., and that's not willful misconduct. So unemployment's your only remedy. All right?
But they're under protected class because they're a nonprofit organization. There's no unemployment to be had.
Okay. Well, then you're really in trouble. I did not realize that they couldn't have to pay unemployment.
They're exempt from the unemployment laws because they're nonprofit.
And I was not aware there was such an exemption. So you, as an employee of that business, were not-for-profit business, have no recourse then.
Okay. That's what I thought. Okay,
oh man, I didn't even realize they did that, George.
They do it.
Yeah.
get away with it, but
Yeah, I thought all jobs would come with unemployment compensation, but you're saying they're an exempt entity. So there's a lesson. Let's look that up and confirm that. But that might be a lesson for all of us, which is if you're offered a job at a not-for-profit organization, you better find out if they're going to voluntarily, participate in the unemployment compensation system, or if you're on your own if they fire you.
yeah.
All right. Thank you very much.
Okay, thanks.
540-0580, 540-0580. Carl Rominger here answering your legal questions on WHP 580. I want to call your attention to weekendappointment.com. That's our website that goes with the show. We've got a couple things there. You can post questions, carry on discussions. I post things that are newsworthy. Also, I have a Twitter feed that feeds into that, so I can kind of give you updates of where I am or what I'm doing. Today at 4 p.m., I'm going to be in Carlisle at an NRA event. That's up on weekendappointment.com. There are a few tickets left for that, so if you contact the folks, there's contact information on there. You can confirm that there are tickets available, but they did tell me as of about noon that they had a few spots available. It's $40. It's a great event. If you want to come, I'm not the guest speaker. I'm nobody special. I'm just going to be sitting at a table, chowing down on a meal like everybody else. But it is a lot of fun. I've done many of these, and I highly recommend it. If you miss it this year, I'll try to make sure I announce it a little sooner next year. 540-0580. Feel free to call in. And, of course, if you're on Facebook, feel free to friend me. I'm always happy to add a few new friends to the page. So, again, feel free to do that. You can also use Facebook to post funny things about me like my friends do. And Shane, I think, is screening somebody here. So, Deep.
Yes, I just heard this claimant who said that he filed unemployment.
Yes.
And then due to his non-profit organization, he's not getting it.
That's what he says.
That is incorrect.
Okay.
I'm the former director of from the Department of Labor. If he doesn't matter whether he is, unless there are two types of employers in non-profit. One who select that when their employee get laid off, they will pay compensation and then they will reimburse to the system.
Right.
And the other ones are who automatically every quarter pay unemployment compensation tax. So there is no exemption for any unemployed or for any non-profit organization. Unless they are only an organization of one or two employees.
Okay. So what I'm hearing is that he probably has been misdirected. He should apply for unemployment, and his employer is most likely either going to have been participating in the system just like a regular employer would have, a for-profit employer, or they've agreed to be liable for the payments on a case-by-case basis.
That comes from the department. He had nothing to do about that. But if somebody has told him that because of his employer was not covered in Pennsylvania, he is not getting that, that is not correct. Now, as you say, he might not be getting it because of willful misconduct.
Right.
That is entirely a different thing.
Right.
Okay? But every employer in Pennsylvania, doesn't matter what they are covered to pay unemployment compensations.
Deep,
benefits.
I want to thank you for calling in, and that's what I love about the radio here is we always have some experts out there who know what's going on, and I really appreciate you straightening it out before I went down the wrong direction as well, because that's why I was kind of surprised. I wasn't aware of such a thing.
That's what I thought. I said, well, I need to call immediately.
Thank you very much.
Sure.
Have a great weekend.
Yeah. Okay, bye-bye.
All right. See, that's how it works, folks. If you know something and we don't know it, you call in and tell us because it sure helps. Ellen, you're on WHP 580 with Carl Rominger.
Hello?
Hi, Ellen.
Hi, how are you?
Good.
Good. I have a question. I have a girlfriend who, her landlord goes into her apartment whenever she's not home, and I wanted to know the law about, don't they have to give notice about that?
Well, the short answer is it's presumed what's called the right of quiet enjoyment.
Uh-huh.
It's usually written in a lease. Now, a lease can obviously modify that, but the presumption is if it's silent, the lease is silent or month to month, the landlord really can't just come and go as they please. They need to give you some notice, except for emergency type things.
Yeah, obviously that's true.
And realistically, yeah, the landlord does have the right to once in a while just knock on the door and say, "Hey, I just want to check things out." You might have to admit them right that moment, but obviously, if everything's on the up and up, it probably shouldn't be a problem. But I have over the years experienced cases where the landlord does key in and do these sorts of things. I remember one where the landlord was evicting my guy because he, quote, had a woman living with him, and when the judge asked her how she knew that, she said that, well, when she was in the bathroom, she found some tampons, and so she knew that there was obviously a woman staying there. And the judge looked at her and said, "That's strange because we have them here at the courthouse too. Does that mean we live here? And why were you in his bathroom and when?" Case dismissed, basically.
Right.
So the answer is no, they shouldn't be doing that. I would get a new place to live, though. That would be my general advice.
Yeah, that's what I told her. And also I have a question about animals. Is there a limit as to how many, like, say, dogs that the state of Pennsylvania you're allowed to have?
Most places have ordinances. Like, for instance, Carlisle has an ordinance on how many dogs you can have. And I've actually been involved in this because I've had some folks over the years that hired me because they're in violation of the dog ordinance or the pet ordinance, and they have, 5 dogs, and they're only allowed 3 or 4 or whatever it is. And there's reasons for that. I mean, let's face it. You don't need 27 dogs in a 1,000 square foot apartment. But there are people that do it.
Yeah. I just wondered about the limits as to how many. I have a friend who I think she rents a house, and she has 6 little white dogs.
Yeah.
And they bark a lot, and I just was wondering about it.
Yeah, let me tell you this way. Absent an exact ordinance, for instance, Carlisle has an ordinance on how many dogs you can have. If they don't have, if there isn't an exact number, the next question is, and there's no ordinance on the exact number. The next question is, are the conditions such that it's sanitary and it's not animal cruelty? So a lot of the animal cruelty cases we see, for instance, was one recently I saw where they took 8 horses out of a little barn. The little barn probably could have held 2 horses.
Right.
And somebody put 8 in it. And the fact that you can't keep it clean and you can't manage them, I would suspect that if you had a 20,000 square foot house and you had 17 dogs and a butler who took care of them, absent an ordinance, it's probably fine.
Right. Okay. Well, thank you for your information.
All right. No, thank you.
Thank you. Have a good day.
Do you have to go to break here, Shane? Oh, I do? Okay. 540-0580. See you after the break. Hey, welcome back. 540-0580. Carl Rominger here answering your legal questions. Shane's informed me a couple callers want the office number, so I'm going to give the office number. This is not the talk line number. It's the office number, 241-6070. 241-6070. That's in the 717 area code in case you're, I don't know where you'd be, but the 570 or down there in Maryland. 241-6070 is the office number. So there you go, folks. No need to call Shane and ask. 540-0580 is the talk line number, and that's how you're going to get on the air right now. Tony, you're on WHP 580 with attorney Carl Rominger.
Hi, Mr. Rominger. I have a question about unemployment. A person works for a agency that gets them jobs in different areas, such as nursing, it is nursing, and they don't work totally all the time, and in their partial time they collected unemployment. The agency fought this case, and now they want all this unemployment money back.
Okay.
Don't they take that money out and give it to the state? How does that work? They're telling this person that they're a contractor.
I don't know the answer. The answer is unemployment compensation funding comes out of payroll tax.
Correct.
And so it gets paid in by the employer to the state, and that's between the employee and the state.
Okay.
Not between the employee and employer. In terms of a contract, I don't know. I'd have to actually. What I would usually do in a case like this, and the client came in and told me what you told me, I would write a letter to the employer or the contractor and say, hey, state me your position and point me to relevant authority as to, tell me why we owe what we owe and how that actually works, and make them so I can see if they have any valid claim. It doesn't sound like they do to me.
Well, that's what I thought. And the thing is, they have done that, and what they did now they don't give them any work. So now there's even less work, and then they owe money every time they collect. They owe this $3,000 of unemployment compensation.
Right.
So it's like a double-edged sword.
Go figure.
So it still needs some litigation, I guess.
Yeah, absolutely.
Okay.
All right.
Thank you very much.
Thank you.
Bye-bye now.
Yeah, that's something I like to do when somebody tells me, this is what somebody claims, and it doesn't sound right. I always like to go to them and say, tell me. Thing with lawyers is a lot of times we find that we can convince each other of our relative position. So it's not unusual for somebody to write a letter I disagree with, then go back to the other lawyer and say, or counsel, and say, what are you trying to get at here, and what are you basing this on, and what's your authority? Basically saying, if you're really sure, show me. And sometimes if I get a letter like that, really sure, show me, I send them the case I'm relying on. Now, sometimes in litigation, we might, hold something close to the vest because we're intending to surprise somebody at some strategic point in the future. But usually it's better just to get it all up front and go that route. And you don't have to write these nasty grams to each other. You just got to kind of, convince each other what's really going on. Lucy, you're on WHP 580 with Carl Rominger.
Yeah, I have a question about an employment contract.
Okay.
So I signed a contract for a job. They told me they would pay me a set amount of monetary compensation. And then as part of my benefits, I would get like health and medical, dental, vision, yada, yada. So I worked, and then when the medical costs went up, the medical, premiums went up. Now they came back to me and said, well, your insurance premiums went up, and so we're taking it out of your pay now, so you're going to get less pay. Now, my premiums have never been taken out of my pay before, and they went up last year, and they were not taken out of my pay. But now this year, they are going to take them out of my pay. And it says in my contract I'm getting paid a set amount.
Right.
And then my medical and all the other stuff is actually in a separate section called Other Benefits. Do I have a leg to stand on to say, what are you doing?
Yes. I mean, if the contract says this is the way we're going to do it. Now, you have to look at the contract as a whole to make sure there's not a weasel clause in there somewhere that says, oh, yeah, by the way, we're free to change any portions of this at any time.
Well, they do say that they can change it, but then the whole contract has to be renegotiated. And they didn't say that. They just kind of sprung this on me. And I said, well, wait a minute, that's not the way it was done last year. That's not the way the contract reads. I would have never accepted that dollar amount if I knew, as in, premiums will continue to go up, that I would continue to get less money.
Makes sense.
Otherwise, I would have made the decision understanding that.
So the next question is, what's your remedy? What's the contract say if there's a breach of the contract?
Well, I guess we both go back to the table and renegotiate.
Yeah, and that's probably the trigger, or if there's some penalty clause or violation of the contract.
Yeah.
But usually, a lot of times, those contracts will also say, oh, by the way, if there's a fallout between us, here's the most you can get. A limitation.
Yeah, it doesn't say that way. And the situation is, I'm very happy at this job. I like it. I don't want to make trouble.
And we're back to that same scenario we were talking about earlier with another caller, where you're like, I have a remedy potentially. Maybe I complain, maybe I don't. But I think you're doing the right thing by putting it out there on the table. And maybe you go back to him and say, listen, I want to continue working here. I'll meet you halfway on this.
Yeah, I did. And they said, this is the way it is, and so I feel like I need to start, maybe looking for something else. But then here's the second piece of that question then. I have a time that I have to give them to work out, notice. And so if this is putting me in financial strait, is there a way that legally I still have to work out that notice, even though they change the contract?
We might say that they're in breach, and that undoes the contract. Therefore, no, you don't have to honor that.
Okay.
But I would want to read the contract in its entirety before I'd render an actual opinion on that.
Okay.
All right?
Thanks. I appreciate it.
No problemo.
Mm-hmm.
Thank you very much. 540-0580. Make sure you go to weekendappointment.com and claim that free will. If you don't have a will or you've done a will and it's been, say, more than a couple of years, 5 years or more, it might be time just to get the language updated, to look at it, to make sure it's all still correct and it does what you want. Maybe your nephew Shane has done something to displease you. Martha, you're on WHP 580 with Carl Rominger. Martha.
Martha. Oh, hi.
Hi.
I have a question about emancipation in the state of Pennsylvania.
Yes.
Under what conditions can a minor child become emancipated in the state?
The court has to determine that they're capable of caring for themselves without direct parental control. And I don't know if there's a magic age or not off the top of my head that you have to be at least 16 comes to mind, but I don't think that's even a requirement. But the judge has to make that determination. There has to be good grounds for it. And as a general rule, most of the emancipations we see are done with the assistance to children and youth or social services.
I see. And what would be good grounds? Do you know?
Well, good grounds would be, my parents are drunk and not able to care for me. Here comes the music, Martha. Gotta go.
Okay.
All right, folks, I'm going to be heading over here to this NRA event. Look it up on weekendappointment.com if you want to join us at 4 o'clock, or you can probably start as late as 5 o'clock in Carlisle. Call the number that we've got up there. Make sure there's still ticket availability. It goes from about 4 till about 9 o'clock. They got an auction. They got all kinds of great stuff. And as always, post your legal questions on weekendappointment.com. See you next week.